So we've been learning, I think, today, or understanding about custody of kids, access to kids, child support, spousal support, and child welfare. This legislation is not about any of those things. Those things continue to be governed by the same legislation that governs everybody else. So the child support tables apply whether a child is on reserve or is off reserve. And, you know, the test about should a dad get to see a child based on the best interest of the child, that all applies. So you don't need to worry about any of that stuff with regard to what the law says. You know, of course, I think given what we've been talking about in terms of context, I think you need to think about how the experiences of these things might be different for average women, but in terms of what the law says, this law is not about that. So I think you outlined really well what the situation was before the legislation, so I'm not going to repeat that. Other than to say, the example was used in Ontario, but that's true right across the country. So, you know, in BC, the legislation about division of property and rights of access to property, you know, are written by the provincial government in BC, and people who were living on reserve in BC couldn't have access to those laws. The one other piece of legislation that didn't apply, that was a problem, was the Emergency Protection Orders Act. But the legislation that allows, under the Family Law Act, people who are experiencing violence to say, I need to be able to go to court, and rather than me running away, I need to have the right to live in this home and keep the abuser away. That legislation wasn't available. So that was another gap that was missing for unreserved property. And so the reason why there's this gap, just to be really clear, is that the Indian Act covers what happens to property on reserve. A question about property on reserve, you go to the Indian Act. The Indian Act said nothing about what happens when people who are in a partnership or in a relationship split up or if one of them dies. So it was that silence in the Indian Act that led to this gap in the legislation. And one of the other things I guess it's important to think about is that that gap applies to the property, it doesn't apply to the people. So if there's a problem with the property on reserve, that problem could exist whether the person in the relationship is Aboriginal or non-Aboriginal. So it's not that the people don't, you know, the individual as an Aboriginal person in a relationship or as a non-Aboriginal in a relationship with an Aboriginal couldn't ask. It just was that piece of property was the question. So again, what was it meant to address? You're supposed to address, this legislation is supposed to address this gap. And I think it's pretty obvious why that gap was a problem. Often, a couple's main asset, the only thing that they put any income into or invested in or are able to invest in is their property. And that property is on reserve. It is the one thing that they hold together that has value there's no legislation that applies to it. There's no way to resolve the disputes that might come upon the breakup of a relationship. What it meant was that when relationships end, and the certificate of title or the right to own that property on the reserve, when that relationship ended, someone got to say, the person who was entitled to the property, so usually the person who was a registered Indian, and who had the certificate of title or the property interest, got to just kick the other person out with no consequence. And there was no rules about how it would be divided or who got to be there. Just to back up one step, so property that's on reserve technically is owned by the Crown. So technically all that land is owned by the government, but as well in India. But it's given to the First Nation, to the reserve, or to the band, to hold communally, to hold it for the property of all the people who are part of that band, part of that reserve, or part of that First Nation. And if that sounds easy, it's not, because then it comes to the question of, well, who's in this reservation, who's entitled to this access to this communal property? And that is a list that is usually kept by both the government. They keep a list of 40 Indians, and that's a defined term in the Indian Act, who have a right, who are listed as band members, and it's also kept by the band. So there's a list of people, and that doesn't necessarily mean that all those people live on the reserve. You may well have clients that you've served to if you're in Toronto or live in Bay or in Sudbury or whatever, but they're on a band list back home. They have a home reserve. And so they are one of those people who the land is being communally held for. Again, I probably don't need to speak too much about the fact that that land is not usually at all represent the traditional land of that territory. It's usually much smaller, it's usually not the right amount of land, and it's usually under-resourced. So you've got this smaller bit of land held for communally by a group of people. And then different bands have different ways of dividing up that property and holding that property. And so you often have a certificate that has Emily Hill on it that says Emily Hill holds this land. And I get to own it within the context of its reserve land on the reserve. So when I talk about a couple breakers up before this legislation, if you own a piece of property in Toronto, it could be that in the couple, let's say it's in the man's name, it's written down, he's got the right to sell or buy or mortgage or whatever he wants to do on that land. And through marriage, a wife would also have the right to have that on that land, whether or not she's listed. But when they split up, there's all kinds of rules about how that happens. So what we're talking about is with that reserve land is the certificate or the title that goes to that person. That's who it would follow. So when we're talking about that second point, when the relationships end and the property is held by one person, that one person is usually the Indian who's registered with that reserve. But sometimes it could be that there's two people from the same reserve who are married or living together in a relationship. They also could be both listed, but that wasn't usually the case because of all kinds of historical reasons that you probably could understand. That was usually what you went down the male line, usually went to men. And so the situation would often come with the partner, with one partner being the one who held the title, when that relationship ended, the other person had no rights to go any further, to seek any remedies, to stay or get any interest. That's the problem. So, what does the Act say? How does it try to solve this problem? Well, the first thing the Act says is, you First Nations, you Indian bands, the same kind of word, those different words that mean the same thing, who have this reserve, you can make your own rules about this to deal with this problem. You don't have to follow our rules. Well, that sounds good to someone who's interested in making sure that decisions about justice are made by the First Nation communities themselves. That sounds good. What it says is these rules are in place until you enact your own, and if you don't enact your own within a year, then ours will come into place. And it sets out all these rules for how you have to enact your own rules. So if I'm, chief of my community, and I'm going to write our own rules, it has to pass by a vote, there's all these rules. So sounds good. Maybe the communities are going to come up with their own rules that better suit their own needs and reflect better their own values for how this land is going to be held. As was mentioned, the Act is not yet enforced. So it's written, it's been proclaimed, but at some point down the road, the government will pass through regulation something that says this comes into force, June 1st, 2014 or something. So it's not yet enforced. We don't know when it will come into force. I don't know when it will come into force. So the first thing that you guys probably will want to know in terms of going forward, you leave today, you don't think about this, you throw this in your cabinet if you're like me, and then, in 18 months, someone's going to come into your office and say, I've been kicked out of my home, which was on reserve, and you're going to think, oh my gosh, what was that reputation? The first thing you're going to want to know is, when was it proclaimed into force? That will become important, because you need to know whether the law applied. And does this community that this client is from, have they passed their own rules, or are they being governed by this Act? So I can't answer those questions. You're going to have to do that legwork on your own. Or call Aboriginal Legal Services of Toronto, which try to help you. So there's three kind of parts. There's emergency protection orders, occupation, and possession. And you probably maybe talked about this, but occupation just gives you the right to be in a place. It doesn't give you legal rights to it. You can't sell it, you can't mortgage it, you can't do anything like that, but you have a right to be there. So that's possession and occupation. So it applies to spouses or common law partners if at least one of them is a First Nation member or an Indian. So it is interesting, it is common law, you don't need to be married. Common law is defined by the one you're living together. Same sex, opposite sex, doesn't matter as long as you're in a conjugal relationship, so in a spousal-like relationship. And so what's important about this is you might think that this is only about your Aboriginal clients, but it's actually about your clients who live on reserve, because you may have a client who has a partner who's Aboriginal, and they're the ones who have an interest in that property. And they're often the ones who traditionally were most at risk, because if their partner was the First Nation person who was registered, and the relationship ended, and they're not from that community, they're either not Aboriginal or they're Aboriginal from a different reserve, they're often the first to feel or be told they got to get out of there. They've got no right to be them. They can leave with their kids, or they can leave and take their kids, but they don't get to stay. And what is important to know about this legislation is this is designed to protect them. It's designed to protect anybody who's either married or living in a common law relationship with someone